Hello, everybody. We are going to deal with the Registration Act 1908. So, it is very important when we start an act, we need to focus on something. So, the slide 1 clearly emphasizes on those things. First, that this act is Act number 16 of 1908. It was enforced on 1st January 1909. It extends to whole of India. Earlier, it used to be the Indian Registration Act 1908, but now it is omitted. The word India is omitted in 1969. What is the purpose? The purpose is to consolidate. Consolidate means to bring together the laws relating to the registration of documents. Now, it is very important when you start with any act to focus on the index part, right? When you focus on the index part, it will help you to understand that what all topics are dealt in covered in the particular act. So there is 15 parts. This act is divided into 15 parts. Today I'm going to deal with part 2 that talks about the registration establishment. Now, there are four authorities that are mentioned under this. Authorities under these acts are: first is Inspector General of Registration, that is given under Section 3. Then they talk about registrars and sub-registrars, that is talked about Section 6, and inspectors of registration office, that is talked in Section 8. It is very important you people to understand the importance of some sections. There you don't have to remember all sections. You have to remember the importance that there are some sections that are very important and they can be asked in exams. So I will be mentioning them separately so that it is easy for you people to understand that these sections are important for the prelim basis. Now you've understood that there are four such authorities that have been created under this act. Now moving towards the next section, that is Section 3, and the Section 3 basically talks about the Inspector General of Registration. So very important. Now please understand, I've highlighted all the important parts on the slides, but I'll read the section. That Section 3 talks about that the state government, who has the power to appoint, the state government, the word is used shall, that is mandatory, that the state government shall appoint an officer to be the Inspector General of Registration for the territory subject to such government. Now, in the proviso part, it is written that it is not important that the state government appoint an officer, especially that you are designated for the Inspector General of Registration, but the state government, instead of making such appointment, can direct all or any of the powers or duties hereinafter. Hereinafter means that section 3 onwards, upon the Inspector General, that any officer that is appointed by the state government will have to exercise and perform the powers of the Inspector General that has hereinafter mentioned. So it is not important that the state government has to appoint, has to give a special designation to somebody, to some officer. He can also, if there is any officer doing any other office work of the government, can simultaneously be the Inspector General. So, subsection 2 clearly states that any Inspector General may hold simultaneously any other office under the government. So, either the state government can appoint any officer, that has to be only the Inspector General for registration, or also has the power that any other officer appointed by the state government can also do the work of the Inspector General for registration. Clear? I hope it is clear. Now section 4 is repealed. We move to section 5. Section 5 talks about that the state government again shall form district and sub-district, and also can alter the limit of such district and sub-district. Now, section 6 talks about the registrars and sub-registrars. Now, here it is important that the state government may. The word may is used for that either the state government can appoint any person or may appoint any officer. So, this is a difference you can see for the Inspector General, that in Inspector General there has to be the officer, whereas in registrar and sub-registrar there can be either person or any officer. And such, obviously in a district there will be registrar, and in sub district level there will be sub registrar. Moving towards Section 7 talks about again that the state government has the power to establish the offices for registrar and sub-registrar. But the important rule here is that if offices are amalgamated, whose office will be amalgamated? The registrar and sub-registrar. That in that case, sub-registrar will not have the right to hear appeal on his own order. Now, Section 8 talks about the fourth designation, that is the inspectors of registration offices. Again, who will appoint? State government may appoint any officer. Now, such inspector shall be subordinate to whom? To Inspector General. I hope this is clear. Now, this is section 9 again is repealed. Now, we'll move towards section 10, 11, and 12. Section 10, 11, and 12 has to be read together. What is section 10 saying? Section 10 is saying that if there is the absence of registrar or vacancy in his office, if the registrar is absent or there is a vacancy in his office, then Inspector General will appoint in that behalf. And if Inspector General fails to appoint in that behalf, then the judge of the district court, in whose local limits the jurisdiction of that registrar office is situated, shall be the registrar till that absence or until the state government fills up that vacancy. Clear? Now, subsection 2 clearly says that the registrar of the district, including the presidency town, again is absent or is when his office is temporarily vacant. Then who has the power? Inspector General can appoint on that behalf during the absence of the registrar or until the state government fills up the vacancy. It is important to understand in section 10 that there are two subsections. The first subsection talks about the registrar other than the registrar of the district, including the presidency town. And in the second subsection, they're including that presidency town registrar. The other word that is written is otherwise then on duty, because this otherwise then on duty is dealt under section 11. Now, section 11 says that when the registrar is absent, and the reason for his absent is that he's absent from his office, अपने ऑफिस से absent है वो ऑन ड्यूटी, क्योंकि वो ड्यूटी पे है, तब उसकी जगह क्या होगा? रजिस्ट्रार की जगह रजिस्ट्रार खुद एक सब रजिस्ट्रार अपॉइंट कर सकता है या कोई और पर्सन भी अपॉइंट कर सकता है जो उसका काम करे। लेकिन जो भी पर्सन वो अपॉइंट कर रहा है उसके पास दो पावर्स नहीं होगी। एक सेक्शन 68 में सुप्रिटेंडेंस की पावर ओवर सब रजिस्ट्रार एंड सेक्शन 67 में 72 में द पावर टू हियर अपील्स। Now, section 12 talks about now if the sub-registrar is absent or there is a temporary vacancy in his office, then who will appoint on that behalf? The registrar will appoint on that behalf any person during the absence of sub-registrar or until such vacancies is filled up. Now, what all appointments are happening under section 10, 11, section 12, it is important that such appointments must be reported to the state government through Inspector General. Clear? Now, this is, I have actually connected these sections. These are sections from part 12 that talks about the controlling power. So now you're well versed with the concept that who is a registrar, who is an inspector general, who is sub-registrar. So section 60 that we talked earlier in section 11, that registrar has the power to superintend and control sub-registrar. And under section 69, it is talked about that the inspector general has the power to superintend registration offices, also to make rules and remit fines. So the chronology is Inspector General, Registrar and Sub-Registrar. This is the chronology. And also we have noted down that in section 8, the Inspectors of Registration Office comes subordinate to the Inspector General. I hope this is clear. Section, section 15 clearly talks about that every registrar and sub-registrar shall use a seal that will be bearing an inscription in English or any other language that state government directs. And what will that seal have? The seal will say that the seal of the registrar or the seal of the sub-registrar. Section 16 talks about that there will be some books that is necessary for the purpose of this act, that the state government will provide to the officers of this registrar and sub-registrar. So what will that books contain? That books will contain forms that will be prescribed by the inspector general, sanctioned with the state government, and such books will be consecutively numbered, and that numbers will be in the form of printed numbers that has to be signed. The title page of those, the pages that will be signed. So on the title page of each page, the person who is authorizing or who is issuing such books will sign. Then comes that there will also be a fireproof box. What is the purpose of the fireproof box? The purpose of the fireproof box is to provide safe custody of the records. Now, Section 16A basically talks about that the documents or the books that we talked about in Section 16 will also be provided in electronic forms. Again, the manner will be prescribed by the Inspector General with sanction of the state government. This subsection 2 clearly talks about that these copies shall be deemed to be a copy under Section 57. That means it has an evidentiary value. It will be admissible in evidence as an original document. Thank you, everyone. We'll be moving to part 3 tomorrow.